Welcome to Brief Encounters and this month's episode of the Securities Regulation and Enforcement series. My name is Valerie Mirko, and I'm a partner at Armstrong Teasdale, as well as the firm's Securities Regulation and Litigation practice leader. With me is my co-host, William Nelson from the Investment Advisor Association.
Hi, Valerie. Great to be here as always. William Nelson, Director of Public Policy and Associate General Counsel at the IEA.
And we have a guest speaker today that I'm very excited for William to introduce.
Absolutely, Valerie. I am excited as well. Today we have Michelle Heisner, who's a partner at Baker McKenzie. She is a member of the firm's Global Corporate and Securities Practice Group. She has had enormous amounts of experience, worked as an M&A attorney at a leading global law firm. And I believe you also worked in Australia, Michelle, which is I found really interesting too. But it's always great to catch up with you. Let's just dive right in. I'll start with this. Whether you're a foreign issuer, general counsel watching disclosures, the SEC has really made your summer a lot more interesting. We've got 3 key themes to tackle today. We're going to do disclosure tightening, foreign issue scrutiny, and ESG uncertainty. And I'm going to let Valerie start with disclosure.
Thank you, William, and welcome, Michelle. It's great to see you. So we're kicking off with disclosure, and this is something William and I had talked about in earlier episodes this year during the transition from Chair Gensler to Acting Chair Rieda to Chair Atkins. And of course, as we're seeing and as we're going to discuss today, this is something that has moved pretty quickly. So, Michelle, CorpFin recently revised some CDIs under Reg SK Item 103, and then very quickly followed up with a roundtable on executive comp. Can you tell us what's going on here?
All right. So really excited to be here today. Thank you for having me. And I'm happy to hit our listeners first with our most technical points and get them out of the way. So in June, CorpFin revised 2 CD&Is and withdrew 1, all of them under Item 103 of Regulation XK, which is the item that governs disclosure of legal proceedings in SEC filings. Specifically, the 2 revisions, so those were the revisions to CD&I 105.1 and 105.3, they were largely technical, cleaning up outdated cross-references. And the real meat of the changes then was the withdrawal of CDI 105.2. The division withdrew prior guidance that had suggested that environmental proceedings brought by foreign governments could require disclosure as proceedings arising under, and I'm air quoting here for the listeners, local provisions in Item 103C3. So this withdrawal clarifies that such foreign environmental proceedings are not subject to the disclosure rules under 103C3. And so while these changes, in general, they're pretty subtle, pretty technical, but to me, they're emblematic of what's currently kind of going on at the SEC, which is a push to really re-examine and clarify the rules and guidance that's out there.
And Michelle, does this June roundtable on executive compensation fit into that focus of redoing some of this guidance?
I think so. The SEC hosted a roundtable at the end of June on executive compensation disclosure requirements. The goal was to evaluate the effectiveness of current rules and to consider how evolving market practices should be reflected in future regulations. The roundtable brought together representatives from public companies, investors, industry groups, and advisors to discuss the current state of exec comp disclosures.
That's interesting. So what were the takeaways of the roundtable?
Well, there were a lot, and people obviously don't all have the same views. But in general, I would say one theme is that panelists and practitioners noted, and really they've been noting, just generally in the market, that compensation disclosure has become unwieldy, less useful, and increasingly repetitive. The roundtable really is a part of that broader effort by the SEC to review and evaluate the effectiveness of the current rules and consider how the evolving market practices should be reflected in the future rulemaking, including in this exec comp area that people have really been looking at. I think that the roundtable and the CD&I revisions both reflect an attempt to focus on providing issuers clarity around what disclosure should look like, while also trying to focus in on what's truly material to investors rather than perhaps incidentally picking up non-material items from an investment perspective.
So that is super helpful framing, especially considering, we only have limited time today. I did want to ask you this. I've heard some general counsels in recent weeks saying they're revisiting how they describe risk factors in light of this renewed focus on materiality. Are you seeing that as well in your practice?
Yeah, absolutely. I think that risk factor disclosures are being scrutinized more closely. And that's been a trend that's been going on for a little bit of time now, some time now, not just by the SEC, but by investors and plaintiffs' counsels. Companies are moving away from more generic language and towards more tailored company-specific risks. So, for example, if a company is facing litigation in a jurisdiction with what might be viewed as an especially aggressive enforcement regime, I think that's starting to show up a little more explicitly in the filings.
And I would expect that's also true in the executive compensation disclosure area.
Yeah, one of the things that came up in the roundtable was the challenge of balancing transparency with readability. The SEC's rules require detailed tabular disclosures, but many companies are now supplementing those with narrative summaries or visual aids to help investors understand the rationale behind pay decisions. I think it's not just about compliance with the rule itself, but also about communication.
That's really interesting because we're really seeing a shift from check the box disclosure, which I think is historically what we used to see for public companies, to almost more of a more strategic approach at this point.
Yeah, exactly. And that's being driven not just by the SEC, but by proxy advisors and institutional investors. They want to see alignment between, for example, pay and performance, and they want disclosures that are clear, concise, and decision useful. I mean, that's really always been the goal. It's just how do we get there?
I think there's more calibrating. And I think overall it is a positive development, but we are trying to fit a lot in this month's episode. So thank you for these helpful insights on disclosure. Let's pivot. And William, I'm going to turn it over to you to discuss foreign private issuer developments with Michelle.
Yeah, absolutely. Thanks, Valerie. And the first question or issue I have, Michelle, is that we know on June 4th the SEC issued a concept release on the definition of what is a foreign private issuer. My question is, what's driving this?
So the SEC is responding to a dramatic shift in the foreign private issuer landscape. If we go back to like 20 years ago, most foreign private issuers were incorporated in the United Kingdom and Canada. But over the past 2 decades, we've seen a rise in Cayman incorporated, China-based companies listing in the US. I think the SEC said that it's like about 30% now. Many of these issuers have US-style governance and investor bases, which raises the question, should they still qualify as foreign private issuers?
Got it. And why does that matter?
Because foreign private issuer status comes with lighter disclosure obligations. So there's no quarterly reporting, no proxy rules, and just more flexibility. If the definition tightens, these companies could face significantly more regulatory burdens. And I want to give you a couple of really specific examples that I think are top of mind for current foreign private issuers. The first would be US GAAP. So non-foreign private issuers are required to prepare their financial statements in accordance with US GAAP. Switching to US GAAP from could be IFRS, it could be a local GAAP that you've been working with. It could be quite expensive. Next, I would say are proxy rules. Foreign private issuers are exempt from the SEC's proxy rules, which dictate the content and procedures for soliciting shareholder votes. If you are a company incorporated in another country, even if you aren't listed in another country, that country of organization will have its own rules for shareholder meetings, voting procedures, and corporate governance. Navigating how to comply with multiple sets of rules can be thorny, well, not impossible for some companies. So I think people are, beginning to think about what that might look like. And then finally, I would point out Section 16 of the Securities Exchange Act, which mandates that insiders, we're talking about directors, officers, greater than 10% shareholders, of publicly traded companies not only report their ownership and transactions in company stocks, but also disgorge short swing profits, meaning that insiders if you're currently a foreign private issuer, you're not subject to it. But if you become considered domestic, then your insiders will need to return to the issuer any profits from buying and selling the company's stock within a 6-month period. And I think that in practice could be a major change for people.
Yeah, and that's incredibly helpful, Michelle, to look at, the implications for these foreign private issuers. But as we all know, with SEC rulemakings, there does tend to, be knock-on effects. So are there broader implications from these changes?
Absolutely. So I think that changes in this area could really reshape access to U.S. capital markets, especially for companies in geopolitically sensitive areas like China. It also intersects with investor protection. I mean, there's the concern that U.S. investors may not realize that they're buying into companies with more limited disclosure obligations, as well as questions about fairness to domestic companies who are subject to these greater regulatory burdens. Most interesting to me, though, are probably the broader political economic implications potentially here. Some market participants worry that stricter eligibility rules might discourage foreign companies from listing in the United States. And, a regulatory change here could potentially undermine the US's dominance globally as the capital market of choice. So I think what's key here will be the balance between investor protection and market competitiveness for the regulators as they consider changing these rules.
Yeah, and with all of these changes, and it does sound like it can have, really large impact on a lot of these different organizations, but how are you seeing your clients prepare for some of these potential changes?
Well, we don't ultimately know what the changes will be. At this point, we just have a request for comments, so we're in a wait and see period at the moment. A lot of different ideas for how the definition of foreign private issuer might be revised are being thrown around in this request for comment. But at the same time, I think that some issuers are proactively reviewing their governance structures and disclosure practices. Others are considering engaging with the SEC during the comment period. Others, frankly, I think are looking at options to list in other markets. This could provide an exit valve and decrease their reliance on the U.S. capital markets. It also could make it easier to maintain the foreign private issuer status here in the U.S. because some of the ideas that are being floated around look at whether an issuer is cross-listed or increase the focus on the volume of non-U.S. investors in trading. So really, for current issuers, I think it's a moment of strategic reassessment. But the bigger current impact, perhaps, and I don't know how you would measure it necessarily, is whether this request for comment is slowing foreign companies from acting on listing plans in the United States while they really wait for this regulatory uncertainty to play out.
Yeah, absolutely. And, obviously, as attorneys, we're always trying to read the tea leaves, when the SEC puts these types of requests out. Are there, any precedents or maybe past rulemakings that could help us understand how they might approach this issue?
Maybe. The SEC last revisited the foreign private issuer definition in 2008 when it adopted amendments to simplify the eligibility test. So at that time, the focus was on streamlining and not tightening access to foreign private issuer status. What's different now is really the geopolitical context and the rise of companies that qualify as foreign private issuers, but operate in ways that arguably might resemble domestic issuers.
Yeah, and that's really helpful. But, I was wondering, can you explain just a little bit more maybe what happened back in 2008?
Sure. So the goal in 2008 was to make rules about foreign private issuer eligibility that were easier to assess and comply. They weren't really focused on making things more restrictive. So specifically, the 2008 amendments, they clarified the shareholder and business contacts test used to determine foreign private issuer status. So now, basically, the rule that we're currently operating in is that even if you have a majority of your investors in the United States, you could still qualify as a foreign private issuer if you are incorporated outside the U.S., 50% or more of your assets are outside the U.S., the majority of your officers and directors are outside the US, and your business is principally administered outside the US. So in other words, you could be a foreign private issuer even if you aren't dual listed on another exchange, even if the majority of your investors are in the United States. Another thing that the 2008 amendments did was they allowed issuers to test their foreign private issuer status once a year as of the end of their second fiscal quarter rather than continuously. And they provided greater certainty for companies planning cross-border offerings or listings. So these changes were part of really a broader effort designed to facilitate cross-border capital formation and reduce regulatory friction for foreign companies that were accessing the U.S. markets.
Got it. So, is the SEC just really basically now asking whether this going back to this 2008 test really does still make sense?
Yeah, exactly. The test implemented in 2008 looks at factors like shareholder residency and board composition, but it doesn't fully capture how companies operate or communicate with their investors. So, for example, a Cayman incorporated company with a U.S. investor base and U.S. style governance currently might still qualify as a foreign private issuer, even though its disclosures and investor expectations align more closely with domestic issuers.
Yeah, and that's really interesting because that definitely seems like it may be a gap.
I mean, that's the argument for reform and what the SEC is looking into. One angle is that they're asking whether the test should be updated to better reflect substance over form, looking really deeper at how companies and their investor bases actually function, not just at where they're incorporated or who sits on their board.
Yeah, and thanks, Michelle. That's incredibly helpful and such a wonderful overview of how the SEC is really looking at foreign private issuers. We have another hot topic we wanted to get to, ESG and what some may call the climate rule retreat. And I'm going to hand it over to Valerie.
Great. Thank you, William. And I wanted to echo what William said, Michelle. This was tremendously helpful regarding foreign private issuer, especially for those of us who don't practice in this area. Like, when I work with public companies, it tends to be in a defense setting in enforcement. So it's actually really interesting to hear from the more structuring part of this. So I really appreciated that discussion on foreign private issuer. So let's talk ESG. As we all know, the SEC dropped its defense of the climate rule in court. So as a starting point, and just to set the table on the remainder of our episode, which will be about ESG today, let's first address what this rule was / more accurately is.
Okay, so the climate rule is a rule that was adopted by the SEC in March of 2024. And it was designed to require public companies to provide climate disclosure in their SEC filings. It was intended to give investors better insights into how companies are managing climate-related risks and their sustainability commitments. But I think what's really important to understand is that the climate rule really stalled right out of the gate. So almost immediately it faced litigation. The rule was adopted in March last year, and by April, the SEC issued a voluntary stay of the rule's effectiveness due to ongoing litigation.
So what I find fascinating about the current state of the rule is that it's not been struck down. I'm going to let you unpack that, but what exactly is the current status of the climate rule?
Yeah, exactly. I call it a legally suspended state. I don't know if that's proper terminology, but basically it's been voluntarily stayed. It's not being enforced and it's not being defended by the SEC, but it's still there. It hasn't been repealed. So the question now is what's going to happen in the courts? In March, the SEC ended its legal defense of the rule. And then in July, the SEC provided a status update indicating that it does not intend to review or reconsider the climate rule. And also it requested that the court lift the current stay on litigation and continue considering the parties' arguments regarding the scope of the agency's power to adopt the climate disclosure requirements. So basically, the gist here is that currently the SEC doesn't plan to revisit the issue unless the court upholds the rule.
Which does give issuers a certain amount of regulatory certainty. But can you unpack what this means for issuers? Since the climate rule never actually got off the ground, does it mean anything at this point for issuers?
I actually think it's kind of a big deal. The SEC's retreat creates a regulatory vacuum. So companies are now navigating their ESG disclosures without really having a clear federal framework. And so stepping into that gap, you see states like California, New York, others too. They're advancing their own climate disclosure mandates, which really creates a patchwork of state level requirements that companies now have to navigate.
So, as you said, Michelle, while there's some certainty from the SEC and that we know what the SEC will do, to your point, it opens up a regulatory vacuum.
Yeah, I think that California's Senate Bills 261 and 253 are really good examples of that. And they're certainly not alone. But Senate Bill 261 requires companies doing business in California with over $500 million in revenue to disclose climate related financial risk, while 253 mandates emissions disclosures for companies with over $1 billion in revenue. So what you see are that these laws are already prompting companies to build out internal reporting systems, even if the federal rule remains in limbo. So I think what's important to note here is that the compliance burden is real and already here for many issuers.
Yeah, and I think this discussion is incredibly helpful because, it's really how are companies treating these? We've seen a lot of these state laws, to California, and there's others. Are they really looking at these state laws as, kind of maybe more temporary stopgaps, or are they really building out long-term infrastructure?
I think that most are treating them as long-term obligations because even though the federal rule is in limbo, the state mandates are enforceable. They have real compliance deadlines. Companies are investing in climate data systems, hiring ESG specialists, and working with consultants to ensure that they can meet their reporting requirements.
Yeah, and to me, as a former chief compliance officer of a registered investment advisor, that sounds expensive.
It is, but many companies see it as a necessary investment. The alternative, non-compliance, could mean reputational damage, enforcement risk, and shareholder pressure. And for companies with operations in multiple states or multiple countries, the complexity, it just multiplies. So they're not just complying with California or New York, they're really preparing for a mosaic of requirements, some of which may already be here.
Yeah, and that's, again, incredibly helpful, Michelle. And sticking with the climate theme, we did get the Staff Legal Bulletin 14M in February of this year. Can you talk a little bit about that and just what the impact is there?
Well, I have been calling it a bit of a regulatory ping pong match. So, Staff Legal Bulletin 14M rescinds Staff Legal Bulletin 14L. And then Staff Legal Bulletin 14L, which was adopted in November 2021, that legal bulletin had rescinded prior staff legal bulletins. So, ostensibly, we are today reverting to an earlier version of the guidance.
Yeah, so I'll admit that is a bit confusing. So what are these staff legal bulletins? I think that would be helpful.
Okay. So I think we should just go back to basics here and say that a staff legal bulletin is a type of informal guidance issued by one of the SEC's divisions, in this case, the Division of Corporate Finance. They don't carry the force of law. Courts and the SEC themselves are not bound by these bulletins, but they do provide practical guidance where the rules are ambiguous and market practices are evolving, and they explain the SEC's current views. I think the best place to start is 14L. In essence, 14L made it harder to exclude certain types of shareholder proposals. So among other things, 14L basically said that proposals raising significant social policy issues like climate change, human rights, they could not be excluded under the ordinary business exception, even if they did involve ordinary business matters. 14L also rejected the prior nexus test, which considered whether the issue had a meaningful connection to the company's business to assess whether the proposal had to be included in the proxy. Instead, it focused on whether the proposal raised issues of broad societal impact, regardless of the company's size of operations.
Yeah, and it really does sound like that shift really changed the landscape. Was this something where companies were really caught off guard by how many proposals started making their way into proxy statements?
I mean, I don't know if I can say that they were caught off guard, but certainly the upshot was that you saw unprecedentedly high numbers of proposals that were going into proxy statements, and in particular, a number of very prescriptive ESG proposals. There was a backlash from some investors that the proposals that were getting into the proxy statements weren't really relevant to shareholders, at least as an investment concern. At a very high level, Staff Legal Bulletin 14M cancels out these stricter standards for excluding shareholder proposals that were introduced by 14L, which had made it harder for companies to exclude proposals based on economic relevance or ordinary business grounds. So 14M reinstates a more flexible company-specific approach, allowing companies to exclude proposals if they can demonstrate a lack of significant economic relevance to the company's operations or if the proposal micromanages the company.
Yeah, and that's incredibly helpful. And it really does sound like a mixed bag. So on one hand, you have this retreat from the climate rule could actually embolden activists because there really isn't a clear federal disclosure standard to follow. But on the other hand, when it comes to proxy access, companies have regained some more of their power to exclude shareholder proposals on these topics. So how are companies responding to this?
I think some of them are leaning into voluntary disclosures, using frameworks like those promulgated by the Task Force on Climate-related Financial Disclosures or the Sustainability Accounting Standards Boards, and ramping up investor engagement.
Got it. So ESG here to stay, but it's just become a lot less predictable.
Yeah, exactly. Companies really need to be nimble and proactive in this space.
Absolutely. Well, again, that was incredibly helpful. And I know ESG really is a hot topic for a lot of firms, and it is such a rapidly evolving area. But now I am going to turn it back over to Valerie to do our wrap up and what we're going to do looking forward.
Excellent. Thank you both. Michelle, something that we like to do on these episodes, because I know you're a listener, is to really wrap up with what to watch. What should listeners be keeping an eye on? For the issues we discussed today, Michelle, what should all of us be keeping an eye on?
Okay. So if I'm going to talk about the issues today, I'll say three things. The first is, will this foreign private issuer rulemaking gain traction? The comment period is active and we could see proposed changes by the year end. And this really, this could be like a sea change for foreign private issuers and sort of what's happening with capital markets more globally. Second, I would say, will Corp Fin issue more CD&Is or comment letters in Q3? I think the pace of guidance, it has been picking up. And I see a real effort from the SEC to give companies more clarity on rules. And then the third thing from today, I would say, would be, will companies recalibrate their ESG messaging post-climate rule? I expect to see more voluntary frameworks and investor-driven standards. And then if I could give you a couple of bonuses.
Of course, we love bonuses.
Okay, bonuses not talked about today, but AI. The SEC has not issued AI-specific rules, but it is actively shaping expectations through guidance and comment letters and enforcement actions. And bonus is crypto. We're, of course, seeing a lot of movement there. So I think that those are two areas that are going to be hot.
Because you brought up AI, I do want to mention that our last two episodes were actually about AI as well. So it's definitely an issue that we're all watching very closely. Coming back to the topics from today, meaning disclosure, foreign private issuer, and what is happening with ESG messaging post-climate rule, like what are companies doing to recalibrate ESG messaging post-climate rule? Do you have sort of a call to action at this point for issuers?
Yeah, I think just generally it's probably time to revisit your disclosure playbook. I know we say that a lot, but the SEC is signaling change, and companies that adapt early will be better positioned.
That makes a lot of sense. Well, Michelle, before I thank you for joining us, I do want to mention that you were one of the early inspirations of this podcast series, because when the DC Bar launched Brief Encounters, you did some of the earlier episodes. And I remember you and I talking about how there was no consistent securities podcast. So thank you, not just for joining us today, because you were incredibly insightful, but also for being one of the reasons that this monthly series exists at this point.
Thank you to you and Will for making this happen and for having the monthly series. I always listen to it. I think it's incredibly informative.
Excellent. Well, thank you, Michelle. Thank you, William. This wraps up this month's episode of Brief Encounters Securities Regulation and Enforcement series. I know that we've been getting more listeners lately, and I hope that continues. And thank you again for listening. And until next time.